I'm Sunny Nolan, a partner in Husch Blackwell's Labor and Employment Group. Thank you for joining our program today. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please feel free to submit them in the question box. However, unfortunately, we won't have time today to answer those questions. We will collect them and then attempt to maybe do another presentation covering your questions. But we have a lot of material that we want to make sure we get to. All the materials for the presentation are in the program materials folder, which you will also find at the bottom. This program has been approved for legal education hours. To report your hours, please click on the CEU icon at the bottom of the screen, and a certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We really do appreciate that feedback, and we use it to plan our future programs. We want to make sure that they're applicable to your business needs. Want to introduce you to the panel. Presenting with me today, you'll see Eric Eisenman on your screen, Amanda Garcia-Williams, and Elizabeth Samples. Eric helps businesses manage their most valuable assets, their employees. Clients trust Eric's ability to offer practical, effective advice on the many labor and employment issues that arise in the workplace. He counsels employers of all sizes, from small businesses to Fortune 100 companies, often helping them draft and enforce employment contracts, restrictive covenants, and other workplace agreements. He assists clients in the financial services, manufacturing, and healthcare industries, among others. As the firm's Chief Diversity, Equity, and Inclusion Officer, Amanda supports the development of an inclusive culture. The granddaughter of migrant workers, Amanda has a lifelong passion for diversity and inclusion. Her enthusiasm for civil rights led her to begin her career as a labor and employment attorney in private practice. She then transitioned to the DEI space 12 years ago to help organizations create more inclusive environments. And finally, Elizabeth. Elizabeth serves educational institutions in various areas of compliance. She supports colleges, universities, and schools with day-to-day counsel, investigations, training, and policy and system development. She draws on her experience as an attorney for the U.S. Department of Education, Office for Civil Rights, in supporting institutional non-discrimination efforts, including compliance with federal civil rights statutes and regulations, such as Title IX, the Americans with Disabilities Act, and Title VI of the Civil Rights Act. Elizabeth frequently conducts internal investigations for institutions handling various student conduct, employment, and discrimination matters. That's all for the housekeeping items. Let's get started with the program. Well, I'll say this. We got past COVID. I felt like we were in a pretty good place and still working through the work from home issues that have kept Elenis attorneys and HR professionals very busy the last few years. But a fresh set of challenges has appeared to navigate for Elenis attorneys. Our goal today is to advise you about this United States Supreme Court's decisions, what they actually held related to affirmative action, also privacy rights, speech rights, and answer a few questions, including what is unknown. Unfortunately, there is a lot that is still unknown with the cases that we are going to go over, but we want to make sure that we are cutting through the headlines. The headlines that are getting clicks are not the best way to get your compliance advice. And with that, I will start with Students for Fair Admissions versus Harvard and North Carolina. It's been referred to a lot now as SFFA because it's quite a mouthful. The headlines that I have been reading say that affirmative action was ended with the Supreme Court's decision. Elizabeth, I would like to start with you because you are a higher ed attorney. Can you tell us at a high level what the court actually held in this case?
Yes, Sunny, thank you. I'm happy to. And as Sunny said, we'll spend a few minutes talking about sort of what the case, what the court actually held in the case, and then I'm gonna, turn it over to Eric and Amanda to talk about some of the implications for other industries. But with respect to higher education particularly, the court held that the race-conscious admissions programs at Harvard and UNC violated the Equal Protection Clause of the 14th Amendment. So both Harvard and UNC are subject to Title VI of the Civil Rights Act as well, but the court analyzed the facts under the Equal Protection Clause, referring to prior cases stating that discrimination that violates the Equal Protection Clause also violates Title VI. So the court discussed the particulars of each of the programs. I won't go into all the details about them, but essentially each of the institutions was engaging in a holistic review of applicants, but allowed for plus factors related to applicants' race, using a tip system or plus factors towards admission. So the Supreme Court applied the strict scrutiny test that is used to evaluate racial classifications under the Equal Protection Clause. And in order for a racial classification to be permissible, it must pass the strict scrutiny test, and so must further a compelling government interest or be narrowly tailored. And previously, the Supreme Court had held that achieving the educational benefits of a racially diverse class was a compelling government interest in the cases of Bakke, Grutter, and Fisher. However, in SFFA, the court held 6-3 that achieving the educational benefits of a racially diverse class was not a compelling government interest, and explained its decision and its finding in finding the programs unconstitutional with several different reasons. And I'll just kind of walk through those briefly. So first, the court said that the compelling interest of the educational benefits was too vague, and that the court could not meaningfully review the value of diversity that was stated by the institutions. Second, the court found that the admissions programs were both over and under inclusive, and that there was not a meaningful way to show a match between that asserted benefit and the admissions program. Third, the court emphasized that for schools like Harvard and UNC, admissions is a zero-sum process. And so as described by the court, this means that if race is a plus factor for some students, it's essentially a minus factor for others because there are only a limited number of spots. It's important to note here that this is not true for all schools, right, who are not as selective in their admissions processes. We have many clients who have open enrollment and admit applicants as long as certain admissions criteria are met. So this particular factor would not be as applicable to them. And then the court found that using race in admissions relied on stereotypes, that students from certain races would have certain perspectives or experiences that they may or may not in fact have, and that consideration based on such stereotypes was impermissible. And then finally, the court referred to the programs as having lacking a logical endpoint, and this tied to prior language included in Justice O'Connor's decision in Grutter, that supporting the compelling interest of achieving educational benefits would have an endpoint of 25 years, which would have put us at 2028. So that's sort of a overarching sort of description of the holding. There were just two final points to make. One was at the very end of the opinion, the court emphasized that the opinion shouldn't be construed as prohibiting universities from considering applicants' discussion of how race has affected their lives, quote, whether that's through discrimination, inspiration, or otherwise, and sort of allowed for an opportunity for institutions to evaluate applicants not on their race per se, but on stated sort of characteristics or experiences that may make them, a higher contributor to the college community, right, and to support their application. The court was clear, though, in emphasizing that universities can't simply establish through these essays or other application means what is otherwise held unlawful in the opinion, saying that they can't do directly, what can't be done directly, cannot be done indirectly either. And so careful to note that institutions, again, when making these sort of decisions, can't be doing it on the basis of race, but must be doing it on other sort of stated criteria or characteristics through the applications.
Okay, perfect. I thought it was a little bit of an unfair question since this opinion was about 240 pages to say, right, just at a very high level, but there is a lot to cover. Why was the decision so long?
Well, in addition to the majority, we had 3 concurrences and 2 dissents, so that contributed certainly to the length of the opinion. And just to kind of highlight briefly there, Justice Thomas, you know, in his concurring opinion, essentially stated that he didn't see how an institution could articulate any sort of justify any compelling interest and measure based on concrete evidence. And also indicated that this articulated limitation on the use of race in the majority opinion could extend beyond admission to housing programs and other programming at colleges and universities. We also had 2 other concurrences that discussed application of Title VI and then talked about this sort of time limitation that we, first heard of in Grutter. And then we had dissents, where for example, Justice Sotomayor called the holding as fatal in fact, saying that no college and university would be able to meet the strict scrutiny based on the court's decision. And then for her part, we had Justice Jackson in her dissent highlighting various issues, including racial disparities that continue in the United States.
I thought there were a lot of important points in all the decisions. For those nerds out there who also want to read the 200-page plus opinion from the Supreme Court, but I think you definitely hit the highlights. Was this a surprise for you, Elizabeth? Was this outcome a surprise for you or for your clients?
I think most experts expected this outcome, based on questions that were posed and answered in the oral argument, and also because some of the justices have expressed opposition to affirmative action in the past. So I think by and large, the decision wasn't a surprise.
What are the most common questions that you're getting right now from your clients?
So we're getting obviously questions about admissions practices, right, as institutions are reviewing their practices sort of holistically. We're also getting questions about other policies that may be implicated. Schools are reviewing their testing policies, for example, and also legacy admissions in light of this finding. Some of you may have obviously seen in some of the headlines, Department of Education is now going to review Harvard's admissions policies with respect to their legacy admissions and engage in an investigation related to those legacy admissions. And then we've seen some educational institutions who have voluntarily ended their legacy policy as a result of the decision, in part. There are also, I think, questions about how procedures and practices may be analyzed when they're race neutral on their face. So in the case of Harvard and UNC, race was considered as a factor among many, but there are other institutions where there are race neutral policies that are now being challenged. So in a recent Fourth Circuit case, Coalition for TJ versus Fairfax, we believe this could serve as a vehicle, right, for the Supreme Court to answer this question about race neutral policies and how they may be, implicating equal protection as well. And so those are some of the questions that we're getting.
If you're seeing changes, are you seeing changes right now in how your clients are operating or their policies?
Absolutely. I think, institutions are engaging, as I said, in reviews of their admissions practices, using the decision as an opportunity to sort of review and revisit what those admissions goals are and how they're achieving those goals. We're also seeing institutions evaluate whether they will even collect racially identifiable information during the admissions process, the benefits to collecting that information, and whether they should continue with that. And if they do, whether they are walling off admissions officers from that type of data or not. We're also seeing institutions review recruiting materials and other practices to sort of see, even if it's not evidence that the institution is considering race as a factor per se, it may elicit scrutiny. And so taking the opportunity to sort of review some of those materials as well. And certainly to the extent that, intent around these practices and procedures becomes an important factor when there are challenges to these types of decisions. We're certainly encouraging institutions to engage in these discussions and review in a privileged way with counsel, to sort of, again, be prepared for challenges that the institution may be doing indirectly what it can't do directly.
And aside from admissions, are there other areas where your clients feel like this will be impactful, or where you're seeing some impact?
Yeah, certainly. I think many institutions are looking at their scholarship policies and practices even before the decision, but certainly as a result. We have guidance from the Department of Education all the way back from 1994 about permissible race-based financial aid. And there, what is permissible is to remedy past discrimination at the institution itself or to create diversity, which of course is now somewhat suspect as a result of the decision. And so I think institutions are certainly reviewing their scholarships to ensure that they're, being done in a legal and compliant way.
Perfect. Well, that's all very helpful. Obviously, this was very focused on universities and admissions. Eric, I'll switch over to you now. Can a private employer continue to consider race as part of its selection criteria?
Sunny starts with the tough questions, and I will answer your question and give you a little of what I think is some relevant context here. The short answer to your question is that an employer is still permitted to consider race as it is making decisions about hiring, promotion, retention, those sorts of things. Taking a step back, the big headline that I think employers should take away from these discussions about the SFFA decision is that, to be clear, you started, Sunny, by explaining the headlines that we're seeing. Affirmative action is over. Let's remember that the Supreme Court's decision was focused on, affirmative action in the context of educational institutions. The court analyzed Title VI of federal law, which is different than Title VII of the Civil Rights Act of 1964, which is the federal law that governs most private employers. And setting aside, employers who are federal contractors, I think we'll probably talk about that in a little bit, who might have legal or statutory obligations to affirmative action. Private employers have historically been governed by Title VII, which in a shorthand basically means you're not entitled to discriminate against an individual based on any protected characteristic. So the big picture is this case, SFFA, does not by its terms apply to private employers who are assessing race in the context of DE&I programs, making employment decisions. So I think the takeaway is it doesn't directly impact that. Now, as I think we're going to get to here, there are pieces of that decision, like Judge Gorsuch's concurrence, some of the commentary that we've seen from state and federal legislatures, which are suggesting that the court's statements in SFFA should have or portend an impact on private employers in this space. That is what I think is going to be of particular interest to you and me as employment lawyers who are advising private businesses.
Well, I wanted to ask you the tough question right out of the gate, because I know that's what the audience wants to hear. So then the other question the follow-up is, should an employer consider race as part of its selection criteria?
That's probably an even tougher question than the first one, Sunny. But I think the advice that we would give is that to the extent that a private employer has implemented an internal diversity, equity, and inclusion program, that it has, made efforts in recent years to cast a wider net so it is diversifying the pool of applicants that might be coming into its organization, or it has thought more intentionally about the makeup of its employee population and is, setting aspirational goals about ways to modify that. All of that continues to be legal and permissible under the law. So, we're probably not in a position to say this is something employers should consider. I think what we can say is that it is still permitted under the law as long as it's done in a way that's consistent with our historical interpretation of anti-discrimination laws like Title VII.
And so what I'm sort of hearing you say, Eric, really is that in many of the ways that the Supreme Court said to consider race is certainly a safe way to do it as a broader context for the selection criteria, but not a race plus, which is what was really at issue here, was additional points for race.
Yeah, so, I think that's exactly right. I'm sorry, go ahead, Sunny.
Oh, go ahead. Sorry.
Yeah, I was, there's, I think Elizabeth made mention to that language in the majority opinion, which I think is catching a lot of attention, where Chief Justice Roberts points out that, the decision does not preclude an educational institution from considering the way in which race has impacted a person's life experience. Again, our assessment is that that decision, because it applies to a different law than the one that's governing private employers, isn't necessarily an apples to apples comparison. But even if it were, even if we overlay sort of that concept onto the private employer context, there is still a recognition by the Supreme Court that there are aspects of race or impact of how race has impacted a person that remain to be permissible considerations for an employer. So again, that can be programs regarding retention, it can be development of employer resource groups, the sort of things that Amanda, I think, will probably talk a little bit about. And it can also be awareness of race when an employer is thinking about where and how it's recruiting candidates for employment.
Well, so another headline I read this morning was that employers are feeling sort of frozen in place, not sure what to do. Part of that being attorney general letters from Republican states, attorney general letters from Democratic states, right? Or what is the basis for those letters, and should employers be worried about those letters?
Great question. Yeah, and this is where we don't envy our colleagues who operate private businesses, because it's tough to get caught in the middle. But as Sunny described, essentially what we saw following the Supreme Court's decision is legislators, elected officials in different states who are issuing guidance based on their interpretation of what that decision means for the private employer context. You mentioned that there was a letter signed by 13 attorneys general taking the position that the Supreme Court's decision in SFFA effectively meant that private employer DE&I programs are no longer lawful. As you mentioned, it was quickly responded to by another group of attorneys general from different states saying, no, that's absolutely not the case. We even saw some statement by the commissioner of the EEOC after the decision saying, to be very clear, this doesn't impact employers who want to continue to operate DE&I programs or consider race in hiring decisions in the way that they historically have. There's not a clear answer here, which is that, easy, check the box, you can do this, you can't do this. The ground is shifting. And I think depending on the industry that an employer is in, the geography where an employer is located, there are probably considerations that employer should make about the way in which it is structuring its program to ensure that it remains lawful. But the big picture is the law has not changed as it relates to private employers following this decision. It remains the same, which is you should not be making decisions based on race. You should not be setting quotas for hiring on the basis of race, but you are permitted to consider that as an element and to still utilize the same strategies that you historically have.
Okay, that's perfect. And if I had instant replay, I would play that answer again, because I think that's really the critical point, that it did not change. There are lots of things to be thinking about. Just again, to address these headlines of affirmative action no longer exists. And we have obviously a lot of federal contractors on with us today. We have a very broad range of industries on with us today. Can you just briefly comment about are there any affirmative action requirements any longer for any type of employer after this decision?
Good question, Sunny. Yeah, another area where the reality probably doesn't line up with that headline that you identified. The affirmative action, as we understand it today, the Office of Federal Contract Compliance that administers affirmative action, that was created as a result of some executive orders that were entered back in the 1960s, imposing requirements on government contractors, businesses that have contracts with the government over a certain employee threshold or dollar amount. Those remain in effect today after the Supreme Court's decision in the SFFA case. There's nothing, again, if we look at the laws that are analyzed in that case, which directly would overturn or disrupt the framework under which that federal affirmative action program has existed. Now, having said that, Sunny and I have had some conversations with our internal colleagues in this government contract OFCC space, where there are some interesting questions. We saw the authority of the executive challenged during COVID when there was an executive order issued regarding a requirement of vaccine mandates for federal contractors. And there was some question about exactly how far the authority of the executive goes. I think we anticipate some similar challenges there flowing from this decision about whether that federal statutory regime is still sustainable in light of sort of the opinion of the Supreme Court. But as we stand here today, there is no sort of legal basis to conclude that it's been changed or altered in a material way.
Okay. So, like I said, I would just keep asking all the difficult questions. This is sort of a real live example of, after the headlines, obviously employees are not paying attention in the very close way that a bunch of labor and employment and DE&I professionals are paying attention. What if an employer has an employee who refuses to attend diversity training as part of its DEI initiatives? You know, how would an HR person or L&E attorney address that situation?
Good question. You know, I think that some of the cases that we've seen reported where there have been challenges to employer programs or arguments that some of these mandatory programs constitute discrimination have involved instances where an employer is compelling an individual to participate in something that they don't want to, or they say that they have a fundamental disagreement with. I think, again, there's probably a gray area here. An employer generally has the right to, for instance, require employees to participate in safety training. It can require employees to participate in harassment and discrimination training to ensure that we're complying with our obligations under Title VII. I think there's an argument that as long as the sort of training that we're talking about here is consistent with what the law allows, that the employer still could require that. But I think my practical advice would be, if you have an individual who's objecting to that, and they appear to have a bona fide reason to do so, you should think carefully and contact your counsel before you would fire that employee or take other action, because you're probably then setting yourself up to receive a lawsuit and maybe appear on the front page of your local newspaper.
Exactly. Yeah. I think there's going to be a lot of tough questions like that where the gray area is, and we'll be keeping up on that. So if you have those questions, yes, give us a call. I am going to actually switch to Amanda and ask about the DEI concerns regarding, well, first, actually, let me ask you, Eric. I mean, as people are thinking about these, and Elizabeth has already mentioned some of the practices that the universities are obligated to change, right? The law has changed and you have to change those practices. It's less clear for a private employer as to what practices to change, like the training we just talked about. Are there concerns or legal considerations about making those changes, whether it's just to get rid of a DEI program or other types of changes? Are there other legal considerations?
Well, I think that this is a good segue to Amanda, because, you know, what we've historically advised our clients who are coming to us with these sort of questions is, yes, there is a way to implement an internal DE&I program. Yes, there is a way to think about diversity in the context of a broad definition and inclusion that is going to be fully consistent with the law, both before and after SFFA. And on the flip side of that coin, there are things that an employer can do. I alluded to one of them before, which would be, for instance, publicizing that we're going to set a specific quota for a percentage of our workforce that we want to fall in category X, that probably are problematic or could create a risk. And so I think what maybe Amanda can talk about are the ways in which DE&I professionals can think about developing and building those programs in a way that don't put an unnecessary target on someone's back.
Perfect segue, Amanda.
Wonderful. Yes, I can do that. Thank you so much, Eric, and thank you, Sunny. So from a DEI standpoint, I just want to continue to reiterate some of the things that Elizabeth and Eric have said, right? When we think about DEI best practices, I want to make a clear distinction between decisions that are made at the point of hiring someone, deciding whether or not to make an offer to an individual, and a function of a DEI program that thinks about how we are reaching out to candidates, how we are conducting interviews, how we are drafting our job descriptions, and where we are posting those jobs. All of those best practices in hiring and promotion considerations, those are still best practices after the Supreme Court's decision. When we think about something like at the point of you're making a decision about who to hire and you're considering race when making a decision about who's going to get the job offer, That is not a best practice. It never was. That, right? Maybe this is a CDO, as a former labor and employment attorney talking, but really, when I talk to other chief diversity officers, they feel exactly the same way. That was never the intent or the goal of the DEI program. And so that type of practice is absolutely suspect and concerning. But when we think about the holistic function of increasing diversity, not just race-based diversity, but disability diversity, gender diversity, veteran diversity, age diversity, when we think about all of those different elements and how we're bringing people into an organization to make our organization more diverse in that myriad of ways, those best practices that existed before those decisions are still best practices today.
So what I hear you saying in part is that quotas and set-asides really just were not best practices and therefore are not best practices today. And
That's
there's
right.
not, okay.
Yeah, Sunny. And I think that quotas and set-asides, when we think about, a set-aside like 10% of our hires in this coming year will have to be from a particular race, I think those were quite rare. And yes, we're always suspect and never best practices. When we think about targets, however, right, we do have some organizations that want to increase diversity year over year. They may be looking at benchmarking data and saying there's a particular area because of our geography or our client base or our industry where we think we might be underrepresented relative to those benchmarks. And we want to think about, again, best practices in order to bridge some of that gap. Those are more common. And again, they don't mean that we change our process at the time that we decide who we are hiring, but it does mean that we can look at best practices holistically throughout the entirety of our candidate consideration process.
From your perspective, do you believe that affirmative action, and I know that's one type of program, and or DEI are being phased out? Is that really the likely outcome? And this is sort of the start of that.
Yeah, I don't think so. I think Eric and Elizabeth already talked about affirmative action in particular and all of the ways that that is defined and how the court's decision was focused on one part of affirmative action, but that affirmative action in general is broader than that. Same thing with DEI, right? DEI and diversity, equity, inclusion programs are really at the heart of it, thinking about how we create the best workplaces, right? I think the empirical evidence shows that heterogeneous environments where people feel valued, where they feel included, where they are engaged and want to do their best work, those result in competitive advantages when we think about solving complex problems, thinking strategically, being innovative and iterative. Those realities of excellent workplaces that are equitable and inclusive, those realities still exist. And I think as long as organizations continue to want to get that business advantage and want to create excellent spaces and work environments, these types of functions will still exist. Now, they might change names a little bit, and we've talked about that a bit. Now, we might call them something different, but the overall goals of those programs and functions, I don't think they're being phased out at all.
So you are seeing those changes too. I think that we talked about changing the DEI title to, talking to an organization, to Director of Culture and Belonging, to really focus on a different aspect. So are you seeing other types of changes like that, whether it's nomenclature or more than that?
I am. So changes in nomenclature, certainly. So thinking about whether the use of the word diversity or equity or similar language is triggering in some way, or if that's become convoluted with some negative connotation, and if so, should we be changing that language? That actually pre-existed the Supreme Court's decision, by the way. I heard a lot of organizations talk about inclusive first language. We often hear the word belonging, which I think is a It's a lovely umbrella term for the work that the DEI professionals and organizations are trying to do. So changing some of those words to, either avoid some scrutiny or to be more relevant to a broader audience, those considerations are completely valid. And I do see some organizations deciding to change their names for sure.
So I was reading one opinion just around, are you setting yourself up for legal challenges by talking about diversity efforts, And so that leads me sort of to my next question, which is, if a manager is asked by an employee if their organization supports diversity in the workplace, what advice can you provide on how to answer that question?
Yeah, well, first of all, authentically, I always advise that managers answer authentically and in alignment with the actual stated values and practices of the organization. If the organization does have a DEI program and supports DEI initiatives, then I would encourage the manager, again, to understand the question. If the employee is asking, does our company make hiring decisions based on race? Well, that's a different answer, right? And the answer is hopefully no. At the point of making a hiring decision, race is not considered in making that decision. However, if the question is, does our workplace try to create an inclusive environment for people from different identities? Do we value those identities in a way that recognizes some barriers, if they exist, to promotion or advancement or development? Do we intend to grow our organization in an inclusive way? And the organization, in fact, does carry those as core values. And I think the manager should be authentic and say that, yes, our organization does care about those DEI initiatives. We care about you as an individual. We care about your experiences and perspectives. And we're going to continue to do that for you and for all of your colleagues. Sunny, I'm so sorry. I can't hear you.
Sorry. Last question on this case. What are DEI professionals discussing right now in your space?
Oh, everything. So I would say as soon as the Supreme Court decision came out, the first thing we were talking about was pipelining, right? So all employers are hiring individuals, many of which come from institutions of higher education and graduate programs, right? We're a law firm, we hire lawyers from law schools. So the initial parts of the conversation were, how does this affect the future demographics of individuals who have degrees for whom, who we want to hire? That was the first part of the conversation. How do we connect and collaborate with our higher ed partners at the career services departments? And then we moved on to things that were closely related to institutions of higher ed, like our scholarship programs, for example, or our internship programs. So if we have scholarship programs or internship programs as a private employer that are exclusionary in some way, that are race-based, that are identity-based, looking at and talking to our counsel and thinking about the risks associated with those types of scholarship or internship programs. And then, of course, like you've already mentioned, thinking about our own training programs, the way that we communicate the impact of DEI. All of those are very hot topics of conversation among the CDO community.
Yeah, lots to talk about and to consider for sure. And there are lots of great questions that I wish we could answer around this, but I think we will have to pivot to the next case. And that is the 303 Creative LLC versus Elenis case. This case was a web designer who wanted to get into the business of designing websites for marriage, for weddings, and was concerned about enforcement of the Colorado laws protecting LGBTQ plus individuals, was concerned that she would be compelled to create a gay marriage website if someone came to her and asked her to do that. And the court held that that was not required, and on different terms. So I have read a lot. Again, back to the headlines of what I'm seeing, you know, everything from this was a win for free speech and pluralism to this allows unfettered discrimination against the LGBTQ plus community using free speech as a guise. So to cut through the headlines, Eric, I'm going to turn back to you. What was the court's holding in this case?
Yeah, I like your theme, Sunny, which can be the theme of this and maybe the theme of just the way we consume media in general is don't believe the headlines. The headlines on this case, I think, really were Supreme Court holds that private employers can discriminate against LGBTQ people, right? I think that was sort of the takeaway. You will not be surprised to learn that that is not really the holding at all. It's sort of a fairly narrow issue, but still an interesting one and one that does portend for some changes down the road. So to answer your specific question, ultimately, what the court said in this case is that the Colorado statute in play here, which is sort of a state anti-discrimination or a public accommodations law, the kind that most states have, it's a you're not allowed to refuse service to anybody based on their fill-in-the-blank protected class, was unconstitutional as applied to this specific situation, i.e. a web designer, a person who was engaging in some sort of creative activity, who had a personal belief that would prevent them from serving a person, in this case, who happened to be gay. That creative element is what's, I think, the most important piece of this case. It does not, even in Colorado, or even as it goes to the Colorado law, say that any private employer can deny service to somebody because of their sexual orientation or identity. The reason, at least the court says, that it found in favor of the plaintiff in this case was because she was engaging in a creative activity which constituted speech within the meaning of the First Amendment of the U.S. Constitution. Like that masterpiece baking case, sort of the gay wedding wedding cake case, the court is essentially saying if you are engaging in quote unquote protected speech, and here they find it to be protected speech because it involves that creative aspect, you know, the First Amendment protects you against a government infringing on those speech rights, even if it's in conflict with what has been held up as generally permissible, a state law protecting individuals in a protected class. So that's sort of the narrow holding of the case. I think you'll probably have some follow-up questions about what that means going forward, Sunny.
Well, I do. So, and I again, for our audience's sake, I want to just ask some very specific questions. Would this allow employers to not hire LGBTQ plus employees, or allow employees to say, based on their beliefs, I refuse to work with LGBTQ plus employees? Does this case stand for that?
As the holding in this case was sort of outlined, the answer to both of your questions are no. That activity, refusing to work with an individual, refusing to hire somebody because of their sexual orientation or sexual identity, would still be prohibited, or a better way to say it is that a state could still enforce a law that prohibited discrimination on that basis. The question is, how widely or how broadly will the U.S. Supreme Court and other courts interpret this idea of creative activity and free speech? I think it's one thing to say an artist or a web designer is engaging in a creative activity to build a website or to bake a cake. It seems a field afar from that to me to suggest that operating a business or making hiring decisions also constitute free speech. That's essentially the place that you would need to land from a legal perspective if you were able to extend this concept to things like hiring.
Right. Well, and I saw one example of the manicurist, if you will. Someone comes in and wants a manicure for their wedding, whatever kind of wedding. It's a normal manicure. Okay, fine. But if you want a manicure with a bunch of swastikas, that might be a different situation. So that we'll have to see how that plays out as far as what falls under this. And since this was not a business that actually existed, I think it makes it a little bit more difficult for individuals to discern what is really captured here, because the business had not started and there really was not a wedding at issue or specific language that was being objected to, if you will. So
that's a good thing to point out, Sunny, and I think it's worth the audience, being aware of that if we weren't already. Part of what made this case unique, might be the generous word for it, is that the courts sort of seem to pay less attention than they typically do to the issue of standing. As you said, Sunny, this web designer created a website but never went live, never solicited for services, never actually had a gay couple ask her to make the website, and essentially sought this as sort of a pre-enforcement action, when I think historically a court like the Supreme Court might have said, hey, this is not a ripe case for decision. But what it reflects potentially is this is an issue that a majority of the Supreme Court at least sees as an important one, and they were willing to take the case on these facts, even as it laid.
So just maybe at a high level, because I know this is a difficult one too, but in what ways is this case really relevant to employers?
Well, I think what it's relevant is to the extent that an employer is in a space where there is a creative component of the work, baking, designing, any sort of artistic endeavor, there appears to be now a stronger argument that the person performing that creative work is engaging in speech and may have rights that are inconsistent with sort of the laws currently on the books regarding anti-discrimination, that there could be additional protections. And the place that we're probably going to see this most likely are individuals who have religious-based beliefs that conflict with things like an LGBTQ community. That's the area where I think you're going to start to see the ball move slowly, and courts examining whether, again, this portends to a wider degree of protection for religious beliefs that might be inconsistent with existing anti-discrimination laws.
Well, and I want to make sure we have enough time to cover some, because this is excellent discussion. Amanda, I am reading that this opinion is having a negative impact on LGBTQ plus individuals and their allies. And I do think some of these headlines have something to do with that. But are there things that employers should be doing to support those employees relative to this decision?
Yeah, absolutely, Sunny. You're right. Our colleagues are reading these headlines as well, and those particularly with LGBTQ identities and those with LGBTQ people and their families, and those of us who are allies are concerned that it's harming those individuals, right? Whether or not they're experiencing increased discrimination within their workplace or whether they have to worry about that, they are concerned that as they try to access certain services, they will be denied access to those services. And so that is hurtful and harmful, and support for those individuals is really important. When we think about what we can do internally as an employer, I would encourage you, if you have employee resource groups, ERGs, to lean into those ERGs, reach out to the chairs and to the members of those employee resource groups and ask what you can do, what they're hearing, what you can do to support those identities. If you don't have ERGs but are considering forming them, you heard Eric talk about the fact that nothing in the Supreme Court case says that they're no longer able to have employee resource groups. So, reach out to us about how you might be able to do that. If you are not interested in having support mechanisms within your own institution, within your own organization, but are thinking about community-based organizations that you can refer others to, resource centers or trade associations based on identity, sometimes those can be supportive mechanisms as well.
So in order to also support employees who have potential religious objections, should employers be proactive with individuals who might have issues such as 303 Creative's owner did?
Yes, absolutely. So thinking about ways that you are ready to support and hear and consider those religious objectives, making sure that your HR department, that your managers are well versed in recognizing if someone is raising a concern that for their own religious beliefs, they have a concern in the workplace. Yes, HR individuals, your DEI professionals should be well versed in that cultural and religious competency to be able to hear those concerns as well and to address those in very sensitive and thoughtful ways.
And I think I'll say the last thing there, it sounds like there's more in the lower courts as well. But Elizabeth, are there implications for education in this case?
I think really I think the best way to talk about the potential implication is the uncertainty that Eric described with respect to how broadly this may become applicable. Questions about how broadly this decision may be interpreted and how it will affect colleges and universities. The 303 case was analyzed as a compelled speech case, and we've already seen some cases, some challenges in the education context related to compelled speech as it relates to pronoun use. So, for example, a philosophy professor sued his university for violating his freedom of speech when it required him to use a transgender student's proper pronouns or preferred pronouns. And so the school settled that case by agreeing to pay the professor. And so we are seeing some compelled speech cases as it relates to that issue. With respect to analyzing, Title VII's requirements and protections as it relates to religious liberties, which Eric also mentioned. We've had a recent case, Braidwood Management versus EEOC, where the Fifth Circuit was analyzing, again, Title VII's requirement not to discriminate against LGBTQ plus employees and a potential conflict with protections for religious liberties under the Religious Freedom Restoration Act. And so that case analyzed how to apply Title VII's non-discrimination requirements when there is an asserted substantial burden on an employer's religious beliefs. And so I think we'll see more of that kind of litigation. The Fifth Circuit there held that the company was exempt from Title VII because the compliance would substantially burden its ability to operate. So I think we'll see more of that kind of analyzing when we have both non-discrimination protections and these religious liberty issues that are at stake.
Which is interesting because we are talking about First Amendment, and that's what the holding was about. But obviously, religion is implicated. Eric, any other comments on the lower court cases that are looking at this issue?
The only thing I think I would observe, and I might steal your transitional thunder a little bit, is to the extent as Elizabeth teed this up, which is sort of, how employers manage sort of what might be perceived as a conflict between, religious freedom issues and non-discrimination pieces. I think this final case that we're going to talk about is one where we saw a unanimous Supreme Court sort of finding a way to, expand, frankly, both of those sort of interests or address both of those interests in one decision.
Eric, yes, perfect transition. And I did want to make sure it was unanimous, right? This was a unanimous decision, the Groff v. DeJoy Postmaster General case. So tell us briefly what that held and its implications.
So the facts of this case, as you all may be familiar, involved an individual who worked for the U.S. Postal Service and had a religious belief that precluded him from working on Sundays. For a long time, that was not an issue. As if you have gray hair like I do, you will remember for most of my life, the Postal Service didn't deliver on Sunday. But more recently, they have begun doing that through contracts with different other entities. And ultimately, the Postal Service denied this individual's request to not work on Sundays, effectively denied his request for a religious accommodation. And so he brought a claim under Title VII of the Civil Rights Act, asserting that this was discrimination on the basis of religion. And what was interesting is prior to this case, there were, how would I say this? There were two separate sort of analyses that we did when we were thinking about an accommodation case. There was sort of an analysis or a framework that we would use when we were advising employers who were considering a request for an accommodation from an individual who might have a physical or mental disability, a potential claim under the Americans with Disabilities Act or like a state law analog, and a separate sort of framework that we would use if there was a request for an accommodation on the basis of a religious reason. In the physical ADA accommodation context, there would need to be sort of an undue hardship that accommodation would impose on the employer if they were going to be permitted to deny it. I'm giving some shorthand. It's a little bit more complex, but the idea was it was a fairly high standard that an employer had to show if they were going to deny a request for an accommodation. Prior to this Groff case, in the religious accommodation context, the court and lower courts were relying on an older Supreme Court case, which had language that suggested that if a request for a religious accommodation imposed more than a de minimis hardship on the employer, which, as we sort of think about it, is a fairly low bar, that the employer might be entitled to deny that request. So the place where this actually came up a lot in the last couple of years were employers who were seeking to implement COVID vaccine policies. And they had individuals who were objecting. Some were objecting or seeking accommodation based on physical reasons that they couldn't get the vaccine, and others seeking an exemption or an accommodation because of religious reasons. And so employers who were assessing that were essentially being able to sort of conduct this assessment and say, would granting this individual an accommodation or a waiver impose more than a de minimis hardship on my business? And in most instances, particularly where you were in the healthcare setting or something related to that, the employer could in fact demonstrate a de minimis hardship. They were entitled to deny that religious accommodation. So what this court did in the Groff v. DeJoy case is essentially reset those standards so now they're the same. Rather than being a lower bar in these religious accommodation request cases, it's effectively the same as the standard that an employer needs to assess in a ADA type accommodation case. And so I think the end effect is likely going to be that it's going to be more difficult for an employer to deny a request for a religious accommodation. And you may see more successful religious discrimination claims moving their way through agencies like the EEOC or state and federal courts.
So for ADA accommodation processes, we usually encourage employers to have something in place, have forms, have processes, have panels, collect that information across the organization. Are you saying that for religious accommodation requests, they probably should be going down that path as well?
I think that's right. I think in light of this decision and sort of an overarching sort of trend that we're observing with the Supreme Court and other federal courts, finding or increasing protections for religious-based claims, I think that it's going to be important for an employer, again, who's assessing these to be able to demonstrate that it has performed its legal duty, gone through the interactive process, done the assessment that the law requires if they're going to deny a request in this context.
Mm-hmm. And one thing I will add is I think we saw a lot where it's not just religion, right? It's a strongly held belief. And that can make it even more challenging when it's not an organized religion, is just the employees, not just, but it is their strongly held belief. And so that also has to be analyzed in that same way. Elizabeth, any impact on higher ed here?
Yeah, I mean, I think short answer is, colleges and universities aren't treated differently under the standard that was clarified by the Supreme Court in this case. Schools will have to be prepared, just like Eric said, to engage in this interactive process with employees from all levels of staff, to faculty, to administrators, in considering, requested accommodations based on religion, whether that's, Sabbath observance as it was in Groff, or religious apparel, prayer breaks, other practices like that. And I think, as before, even under the de minimis burden, with the substantial increased cost standard, institutions and employers will need to be prepared to demonstrate, right, a showing related to the undue hardship that's been asserted. So
yeah, a very individualized process based on their opinion, just company to company, not even necessarily industry to industry. Amanda, how, if at all, should companies adjust their policies and practices or training other than what we've talked about around DEI or religious accommodations?
Yeah, certainly training. So when you think about training at different levels, whether that's leadership training, HR training, or whether it's training for all employees, thinking about the religious accommodation aspect is important. I think in DEI practices, this provides another opportunity. I think many DEI practitioners are thinking and have been thinking about religion as a very important part of identity for a long time, and integrate that into their DEI programs, leaning into that a bit more, thinking about how we celebrate observances, how we communicate around religious competencies, and again, leaning into those within your organization, your DEI team and others who have historically been thinking about religion as identity, and how we celebrate and embrace those parts of identity, I think will be best practices going forward.
Yeah, I don't think we can emphasize too much the training aspects here, right? I mean, we've talked about policies, we've talked about processes, but then the training is really critical, reviewing what is already in place, and then determining the new types of training that probably need to be rolled out, and certainly for managers. So I think that's really critical as well. Well, I think we are at our hour. I know we tried to cover a lot because you guys are all busy and don't have a lot of time. So hopefully you got a lot of what you needed today, and we will have more programs going forward as more answers are coming out, as we get more questions from you of things that we should be covering. So thank you for joining us today. We hope the information was helpful to you and your organization. As a reminder, this program has been approved for legal education hours. To report your hours, remember to click on the CEU icon at the bottom of the screen. A certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We really value your feedback, and I want to thank my panelists. Excellent job, guys. This was, I know, lots of gray area. Wish we had all the answers, but I think you did a really great job informing the audience and some of the things that they at least need to start looking at, thinking about, and some things that they can start to implement. So this concludes our webinar. I really appreciate everyone's time. Thank you.